My name is Richard Moon, and I'm a member of the law faculty at the University of Windsor. Section 2A, one of the fundamental freedoms in the Charter, protects freedom of conscience and religion. Now, for the most part, and I can say a little bit more about this in a minute, for the most part, the focus has been on religion, religious practices and beliefs. It remains unclear exactly what conscience includes, and there's very little case law around that. And I may say something about that in a minute. Now, generally speaking, when talking about freedom of religion, it's understood as having two dimensions or two sides. One side of it is that individuals within the political community should have the freedom from religion, which is to say, religion should not be forced upon them. They should not be compelled to engage in religious practices, something like that. So that's one dimension. The other dimension is the freedom to religion, the freedom to engage in religious practice without external restriction, without restriction, in the case of the Charter, from the state. So they're really these two different lines. They're related, they can come together at different points, but they really have slightly different concerns. So some of the leading cases around the first dimension of religious freedom, my freedom from religion, concern things like the recitation of the Lord's Prayer in the public schools, or the recitation of the Lord's Prayer at the opening of a town council meeting. Or at an earlier time, and one of the earliest Charter cases was about this, was when the Federal Lord's Day Act prohibited commercial transactions and retail operations and other commercial activities on Sundays. And in each of these cases, the question was whether or not the government, the state, was forcing a religious practice on the general public. Now, one thing that has developed or evolved in the freedom of religion case law is when the court first spoke about what it was that freedom of religion protected, or what it was that freedom of religion banned or prohibited. It talked about freedom of religion as a ban on government coercion. That is, the government could not compel individuals to engage in a religious practice. But what I think has increasingly come to the fore, and the way in which the court's understanding of religious freedom has evolved, is they've moved away from simply that idea. The government can't compel you to engage in religious practice, can't force me to pray in a particular way, can't force me to attend church, can't force me to honor the Sabbath in whatever way. Can't do that, but it also appears now what the government can't do is prefer or support one religious practice over another. So even if I'm not forced to engage in a particular practice, if the government puts its stamp of approval on a particular religious belief system, that itself may be objectionable. So that's one way in which this is developed. So just to illustrate it, in a case called Freetag against the town of Penetanguishene. The town of Penetanguishene, the mayor of the town, liked to start town council meetings with a recitation of the Lord's Prayer. And most people in the audience would stand up, would participate in this, the other councilors would participate in it. Well, a particular individual objected to this, didn't participate, sat through it. Now, one might say this was being forced on him. One might even say there was pressure to conform or compel. But it really appears that what was objectionable in this case was not that anybody was being forced to say the Lord's Prayer, but rather that in a public meeting that was meant to be open to all people, there was a clear preference or support for a particular religious practice. And that what that did was to send a message that if you were a non-Christian, you were not a full member of the political community, or perhaps not a full participant in the meeting. And the Ontario Court of Appeal found that that was unconstitutional. So I think that's one illustration of what I was talking about in the first dimension of religious freedom.